Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled Court of Appeals Order Denying Petition for Rehearing. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, I would like for you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay, so this video will in fact be a continuation of my last video. If you haven't watched my last video, simply pause this video, go back and watch my last video, then come back to this video so you all can be brought up to speed. But for those who have watched my last video, then you all know that we are fighting in the South Carolina Court of Appeals, which simply denied Ma'ok's petition on the appeals on the grounds that they believe that Ma'ok did not provide a sufficient record to support whether or not the trial court had jurisdiction over him or not, which is simply an error which the Court of Appeals don't even want to address. And they also didn't want to address his remaining arguments that he stated in his appeals petition. So now what we have on the screen is in fact an order coming from the South Carolina Court of Appeals. This order is pertaining to Ma'ok's petition for rehearing. The only reason why we filed a petition for rehearing is because that's the step that you must take before you can petition the state Supreme Court, which is the highest court of the state. So now, let's go over the order on the screen so you all can see what's transpired thus far. And it reads, the South Carolina Court of Appeals. South Carolina Department of Social Services and Ma'ok's child's mom, whose name I crossed out, was the respondent, versus Ma'ok, whose name I crossed out, who was the appellant, and the appellant case number I also crossed out. Then it reads, order. Then it states, after careful consideration of the petition for rehearing, the court is unable to discover that any material fact or principle of law has been either overlooked or disregarded, and hence there is no basis for granting a hearing. Accordingly, the petition for rehearing is denied, signed by the 3 justices. So as you all can see, that the appeals court simply denied the petition for rehearing, which we knew was going to happen anyways, on grounds that they didn't want to address the arguments to begin with. They simply trying to blame it on the record, when the record clearly shows that the trial court lacks in personam jurisdiction. So as you all can see, this order was filed on May 30th, 2025. Ma'ok received it, I think, like on June 3rd, and on June 4th, we filed a petition for writ of certiorari to go to the state Supreme Court, which is the highest court of the state. Okay, so we're going to continue to apply pressure. So now let's go to what Ma'ok received from the state Supreme Court, so you all can see that we are now in fact fighting in the state Supreme Court, which again is the highest court of the state. Let's go there. Okay, so now what we have on the screen is in fact a letter that Ma'ok received from the Supreme Court of South Carolina, informing the other parties that Ma'ok petitioned the Supreme Court by filing his writ of certiorari. So now let's go over the letter on the screen. As you all can see at the very top, it states what? The Supreme Court of South Carolina. The date is June 5th, 2025. As you all can see, highlighted in yellow, Ma'ok's personal information and case information are also crossed out. Then it states, very top, this court has received your petition for writ of certiorari, and the case has been assigned the appellant case number that appears above. Please use this number on all future correspondence relating to this matter. All parties to this matter are advised that all filings must comply with the requirements of Rule 242 of the South Carolina Appellate Court Rules, SCACR. Then it states the SCACR are available online at which the website attached. Then it states, additionally, any filings submitted by counsel admitted in South Carolina must include counsel's bar number. The attentions of the parties is directed to the order relating to the inclusions of personal data, identifiers, and other sensitive information in documents filed with the Supreme Court of South Carolina and South Carolina Court of Appeals. The order can be found at with the website. I crossed out the remaining of it. But now let's go to page 2. Okay, we're on page 2. Let's pick this up at the top, and it reads, please note that the responsibility for ensuring that information is redacted or sealed as required by this court rests with counsel and the parties. This office will not review filings for redaction or to determine if material facts should be sealed. Finally, any request for an extension in this case must comply with this court's order dated July 16, 2014. This order is available at the website below, deputy clerk's signature, and CC to all the parties attached. So as I explained to you guys before, this is a fight, but this is a fight worth fighting, especially when you all receive the remedy that you desire. This is not an easy fight, guys. You all must be willing to put in the work and be willing to put in the time to get understanding of what's really going on. You must be willing to go through the good fight, guys. If it was easy, anybody would be able to do it. This is not an easy fight, guys. I can't continue to stress that. This is not an easy fight, but it's a fight worth fighting, especially when you receive the remedy that you desire. So, with that being said, that's all I'm going to do for today. We're going to continue to apply that pressure. If you all need my help, hit me up at my email at y'allismagnified@gmail.com. Off to the Supreme Court we go. With that being said, you all be blessed, and I say shalom.